There will always be tension between our desires for privacy and safety. We're all for privacy until we find out that an invasion of said privacy could have stopped some terrible event. But are we willing to trade our privacy for safety? As Benjamin Franklin said, they who would give up essential liberty for temporary security deserve neither liberty or security. In the case of Sholem Bedard versus Illinois State Police, the privacy question revolves around automatic license plate readers, or ALPRs, and what makes a search reasonable. So we'll discuss that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your and generation be free. I'm glad you could join me today. You know, our society has become really a surveillance one, with cameras everywhere. Everything from, well, public security cameras on light poles to doorbell cameras on everybody's homes. The fact that we're always being recorded is an issue. What you do with those recordings, or what we allow to be done with those recordings, that's a different issue. And that's part of what we're going to look at next. Now, you can find all the links to my resources in the article at the website constitutionstudy.com. I'll talk more about the website and some other things later, but for now, let's take a look at this case about automatic license plate readers. While the term automatic license plate reader is a pretty self-explanatory one, how the case came to be is very important. 6 years ago, United States Postal Service worker Tamara Clayton was fatally shot on the I-57 highway. This unfortunate expressway shooting sparked a movement within the community, Illinois State Police, Illinois Department of Transportation, local police agencies, and the governor's office. On January 1st, 2020, Illinois enacted the Tamara Clayton Expressway Camera Act to fund the installation of approximately 300 cameras known as automatic license plate readers, or ALPRs, across Cook County expressways. 2 years later, Illinois passed a statute appropriating additional funds and extending the program to 20 other counties. To date, the Illinois State Police has installed 344 cameras in Cook County, 78 in St. Clair County, and 44 across 17 other counties. Now, as with so many cases, the road to hell is paved with good intentions. I feel for Ms. Clayton's family and recognize the desire to be safe. But does our desire to be safe trump our rights or the rights of others? On the other hand, does our right to privacy trump the rights of others to be safe? Maybe there's something in the details that can help us navigate this conundrum. The surveillance program works in 2 steps. Installed on the side of the road, ALPRs photograph or detect the license plates of vehicles driving by them. The system then uploads the photo to the Law Enforcement Archival Reporting Network, or LEARN database. This national database compiles and stores billions of license plate photos taken by ALPRs in Illinois and elsewhere. Okay, that sounds terrifying. Billions of license plate photos stored in a national database that can be used to track wherever you go. Unfortunately, it gets worse. Law enforcement agencies across the country flag, quote, hot plates of vehicles that are targets of investigation. For instance, if the car is reported stolen, is used as the getaway vehicle in a bank robbery, or has expired registration, license plate photos sit idle in the database until there is a, quote, hit, when the ALPR detects a hot plate. When police receive notification of the hit, they can enter the LEARN database to retrieve the license plate photo and associated metadata of when and where the photo was taken. This information allows police to see what cars passed by that area at the relevant time and to whom those vehicles are registered. Last month, ALPRs in Illinois recorded 200,161,762 detections and 5,747,483 hits. So all law enforcement needs for the system to start searching this database for plates is to flag them. Yes, There are plenty of reasons for law enforcement to legitimately search for a license plate, but there are plenty of legitimate reasons for them to search for anything. However, in this country, those searches must be reasonable. That usually means the government must get a warrant, but apparently not for searching the LEARN database. Under the Expressway Camera Act, an Illinois State police officer may retrieve a license plate photo from the database to investigate any offenses involving vehicular hijacking, aggravated vehicular hijacking, terrorism, motor vehicle theft, or any forcible felony, including but not limited to offenses involving the use of a firearm. They may also retrieve a photo to detect expressway hazards and highway conditions and to facilitate highway safety and incident management. By statute, all images from the cameras shall be deleted from the LEARN database within 120 days unless the images are relevant to an ongoing investigation or pending criminal trial. Again, if law enforcement has probable cause to search the database, why not get a warrant? Probably because a warrant would limit the scope of law enforcement search to the data relevant to the case they were investigating. Plaintiffs in this case challenged the Expressway Camera Act and Illinois' warrantless use of ALPRs, claiming they violate the Fourth Amendment's protections against unreasonable searches and warrant requirements. They asked the court for a preliminary injunction, preventing the respondents from accessing ALPR data without a warrant. Defendants moved for dismissal due to a lack of jurisdiction. In order for the case to be heard in federal court, plaintiffs or petitioners have to have standing. The court explained this in their decision. Article 3 confines federal jurisdiction to cases and controversies. One aspect of a case or controversy requirement is the doctrine known as standing. Standing requires a plaintiff to have a personal stake in the case. This irreducible constitutional minimum contains 3 elements. Those elements are injury in fact, a causal connection between the injury and the defendant's conduct, and likely redressability through favorable decision. The party invoking federal jurisdiction bears the burden of establishing these elements. Well, this is the standard the court has established. It's not established by the Constitution. In fact, the very idea that I must actually suffer harm before I can seek redress of a bad law violates the First Amendment. Congress shall make no law abridging the right of the people to peaceably assemble and to petition the government for a redress of grievance. When a government entity passes a law that violates the rights of the people, is that not a sufficient grievance? Should I not seek to redress that grievance before I jeopardize my future with an encounter with law enforcement? The first request made by the plaintiff is to prevent the use of ALPRs. First, the plaintiffs seek to enjoin the warrantless use of ALPRs to photograph motorist license plates. As alleged, plaintiffs regularly drive on the expressways in Cook County and the surrounding area, almost always using the same personal vehicle, including commuting from their homes in Cook County to work in the Chicago suburbs, as well as regular other trips by car in areas covered by Illinois ALPR system. With some 300 ALPR cameras across every expressway in Cook County, one can reasonably infer that those cameras will photograph plaintiffs' license plates. The problem with this argument is that when you're in public, you have no reasonable expectation of privacy. But that doesn't mean that the government has a right to collect data about you. Indeed, courts routinely hold that the subjects of government surveillance have standing to challenge that surveillance. Now, whether or not such claims prevail on the merits, plaintiffs surely have standing to allege injury from the collection and maintenance in a government database of records relating to them. So while courts have recognized your right not to be surveilled on your own property, that does not extend to being in public. If that were true, all security cameras, including the one you may have on your doorbell, would be illegal. That would also preclude you from taking a picture or capturing video in public as well. But that doesn't mean there isn't a problem with the ALPRs. Yes, you can be recorded in public with or without your permission. But what about searching through those records? Second, plaintiffs seek to enjoin the warrantless use of the LEARN database. After all, the Fourth Amendment is supposed to protect us from unreasonable searches. What is the reasonable justification for an exception to the warrant requirement? Is it just because law enforcement has already collected that data? Once again, the courts place the desire of law enforcement above the rights of the people. However, the complaint does not allege any facts indicating a substantial risk that police will soon retrieve plaintiff's license plate information from the database. So it's okay if the police infringe on your rights as long as there were no facts presented that there was a substantial risk they'd do so beforehand. I don't know if the judge was simply obtuse or outright biased, but her explanation of this substantial risk is laughable. Indeed, plaintiffs do not allege that they will soon commit or be victims of any of the offenses enumerated in the Expressway Camera Act, namely vehicular hijacking, aggravated vehicle hijacking, terrorism, motor vehicle theft, or any forcible felony. The purpose of the warrant requirement is not to justify a reasonable search, but to prevent an unreasonable one. I'm sure if the plaintiffs were victims of a hijacking or vehicle theft, they would find it reasonable to search the ALPR database for their vehicle. But what about searches for other reasons? Say, an abusive husband or boyfriend trying to track down their victim, or an officer on a hunch or vendetta that wants to surveil a suspect but cannot get a warrant. Couldn't they use the ALPR database to grab pictures wherever the suspect vehicle travels? After all, couldn't an officer simply list them as a hot plate without any probable cause? The court went on to make a rather interesting argument about searches. The Supreme Court has developed two distinct paths to identify a search. First, under the property-based approach, a search occurs when an officer enters a constitutionally protected area for the purpose of gathering evidence against the property owner. Alternatively, under the privacy-based approach, courts ask whether a person has a legitimate expectation of privacy in a given situation. Because plaintiffs do not argue that the ALPR program involves a physical intrusion on their property, the court will examine the Fourth Amendment challenge under the privacy-based approach. The court, apparently in an attempt to justify this violation of your rights, points out that since ALPRs do not physically intrude on your vehicle, you have no expectation of privacy as defined by the courts. They seem to ignore the fact that when an officer enters a hot plate into the database, the government is searching for the effects of a private individual for the sole purpose of determining where this person may logically be. And what about this mass collection of data? As alleged, defendants are holding on to mass surveillance data in case one day some police officer decides to target plaintiff for a specific investigation. Should the government be allowed to surveil the public without any reasonable suspicion, then hold on to that data in case they want to use it in the future? While one day may not be today or tomorrow, it must be some ascertainable time. Because their alleged constitutional injuries are not sufficiently imminent, plaintiffs lack standing to enjoin the warrantless use of the learned database. What about evidence from the past? The entire of the purpose of the ALPRs is to collect data in case the police need it someday. To say that the fact that you cannot point to a specific instance in the future when this might happen to a specific person, when there is clear evidence that it is happening to people every day, is as childish as blaming the cat for wetting the bed. Evidence in this very case shows that almost 6 million hits were recorded in a single month in the state of Illinois alone. While a specific individual may be searched someday, this case shows that on average someone is flagged almost 200,000 times a day. In their defense, the defendants claim they have sovereign immunity. Next, defendants move to dismiss plaintiff's claim on sovereign immunity grounds. Sovereign immunity bars actions in federal court against a state, state agencies, or state officials using their official capacities. Suits against state officials in their official capacity amount to suits against the state itself. Except the very idea of sovereign immunity is antithetical to a nation of laws, not men. People are fond of saying that no one is above the law, but that is exactly what sovereign immunity claims. If you work for the state, you're above the law. Sovereign immunity is a judicial doctrine that prevents the government or its political subdivisions, departments, and agencies from being sued without its consent. The doctrine stems from the ancient English principle that the monarch can do no wrong. If the sovereign, in this argument the government, can do no wrong, then they are above the law. Now, this not only abrogates the concept of a limited government, but violates the Constitution as well. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. Sovereign is defined in the Free Legal Dictionary as a ruler's supreme power, or one possessing sovereignty. It is also applied to a king or other magistrate with limited powers. In the United States, the sovereignty resides in the body of the people. Since in this country, sovereignty resides in we the people, not the government, neither the state nor any of its agents can claim sovereign immunity. Sadly, it appears once again the courts have placed the desires of government above the rights of the people. Defendants' motion to dismiss is granted. Because plaintiffs failed to state a claim, they have not demonstrated that they are likely to succeed on the merits. Thus, plaintiffs' motion for a preliminary injunction is denied. The only reason the court believes that plaintiffs won't win is because they have placed their thumb on the scale of justice by requiring they prove they have already been harmed by this illegal practice. I agree with the court that vehicle owners have no expectation of privacy while on public roads, and therefore the license plate readers themselves do not violate the Fourth Amendment. However, allowing the police to search through the effects, arguably the property of those license plates they have captured without a warrant, makes that an unreasonable search. The fact that the court cannot conceive that the people would conduct illegal searches points to the myopic views so many judges have of their fellow government employees. Personally, I think Judge Palkold should be ashamed of herself. Well, she may have based her decision on the flawed and unconstitutional decisions of her predecessors. She alone is responsible for this violation of justice and basic human rights. I think it's about time we hire presidents who appoint judges based on their fidelity to their oath to support the Constitution rather than their political predilections. It really shouldn't surprise anyone that a government actor in the form of a federal judge leans on the side of other government actors. Again, I understand not wanting to be recorded everywhere, but when you're in public, when you're not on private property, you're going to be recorded. It's going to happen. The Fourth Amendment is about unreasonable searches and seizures, and what makes a search reasonable. If law enforcement needs a warrant to enter your home, if they need a warrant to search your phone records or your bank records, why do they not need a warrant to search where your car has been through a database? Simply because they collected it. See, this is the problem. They think, well, we collected it, it's our data. And to a certain extent it is, but it's data about we the people. And before you start searching, you really ought to have a good reason. And our protections against unreasonable searches are warrants. The fact that you have to go before a judge, prove your probable cause, then get a warrant to allow the search. Now, there are exigent circumstances for emergencies and urgent issues, but in general, you should require a warrant, if for no other reason than to prevent law enforcement from abusing the learned database. Now, this happened in Illinois, but as it's already said, this is a nationwide database with billions of license plate captures. Odds are you're in that database. Do you want to be searched out simply because somebody felt like it? Or do you want to make sure that they have a probable cause to search for you before they go searching? That's really the problem I have with this court case and with the laws as it's being applied. We just ignore the Constitution because, well, we want to keep ourselves safe. We throw out our essential rights for the promise of a temporary safety. We really don't deserve either. Now, before I go, I talked about the website constitutionstudy.com, where you can find the text version of this episode. You can find all my links. You can also find my mailing list, my other features that we have on there. You can find the Patriot program. All of it's there. The website is constitutionstudy.com. Going there and sharing that content is a great way to support the work that we're doing. You can also support us financially, either through buying things through the store or just donating, again, through the store. You'll find it on the website. Another thing you can do, I found this great little course called The Miracle of America, and I made a deal with them. So I thought it was such a cool course. It talks about our history from the Pilgrims through the drafting of the Constitution. Helps explain why the Declaration of Independence and Constitution were drafted the way they were. But I made a deal with the owners to get you a lesson absolutely free. See, when we're talking about rights, like the Fourth Amendment right to be the right protected by the Fourth Amendment to be secure from unreasonable searches and seizures, that comes from an understanding of God's natural law. So that's the lesson I got you. Go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You'll go to a custom landing page just for my listeners. You can read up all about the course, but most of all, you can enroll for your free lesson on God's natural law. You get a downloadable study guide. You get an hour of content, either audio or video, all of it absolutely free. Why? Because I think you'll like this course so much, you'll want to buy the whole thing, which just costs $17.76. Find everything you need at the website constitutionstudy.com/1776 study guide. You can also support us with your cell phone. Go to patriotmobile.com/constitution and join us on America's only Christian conservative wireless provider. You get great 4G and 5G coverage across the nation. You get great 100% US-based customer support, and their prices are pretty good too. Best of all, when you pay your bill, a portion of that goes to supporting groups that are trying to protect our rights, constitutionally protected and otherwise. Join us and help preserve your rights with your cell phone. Again, that website is patriotmobile.com/constitution. And if you use the code Constitution at checkout, you'll even get free activation. So join us there, please. And in fact, join all the work that we're doing here at the Constitution Study. Whether it's speaking engagements or books or radio or online events, participate, share, let other people know. By sharing this information, you're helping to share the blessings of liberty to everyone who calls this great nation home. And I hope you'll share it with friends and family and bring them along next time for the Constitution Study.